Good evening and welcome to Legal Commercial News. Today we bring you an important case involving the repossession of a vehicle under the Hire Purchase Act 1967. The case is Public Islamic Bank Berhad and Edwin Kasian decided by the Court of Appeal in 2025 and reported in 2026. This case concerns the right of financiers and consumers in hire purchase transactions and clarified the procedure that must be followed before a vehicle can be repossessed. So to walk you through on what was going on, in 2008, Public Islamic Bank entered into a hire purchase agreement with Mr. Edwin for a recognition Mercedes-Benz CLS350. Under this agreement, the hirer obtains possession and use of the vehicle while ownership remains with the financier until all installments are fully paid. Over time, Mr. Edwin has failed to make the required installment payments, and according to the evidence before the court, there were outstanding installments for at least 7 months. Because of this default, the bank intended to repossess the vehicle. However, there was one more important legal issue. Mr. Edwin has paid more than 75% of the vehicle's cash price. Under Section 16(1)(a) of the Hire Purchase Act, where a hirer had paid more than 75% of total cash price, the owner cannot simply repossess the vehicle. Instead, the owner must first obtain leave from the court where proceeding with the repossession process. The bank therefore applied to the magistrate court and successfully obtained leave through an ex parte application. The respondent later challenged this leave, arguing that he should have been given an opportunity to be heard before the order was granted. The magistrate court, however, rejected his argument, and later the High Court agreed with him and set aside the leave order. The matter was then brought before the Court of Appeal, and the central question was, must an application under Section 16(1)(a) be made inter partes, meaning both parties must be heard, or can it be made ex parte without first notifying the hirer? Let us now go live to the courtroom where the appeal is being heard.
Court is now in session. This appeal concerns the interpretation of Section 16, Clause 1A of Hire Purchase Act 1967. This court will hear submission from both parties. Counsel for the respondent, you may now proceed.
Much obliged, my lord. Our position is clear. The respondent respectfully submit that the application for leave under Section 16(1)(a) should not have been made ex parte. The purpose of Parliament introducing Section 16(1)(a) was to provide additional protection to hires who have already paid a substantial portion of the purchase price. My client had paid more than 75% of his dues. As such, he had acquired a significant financial interest in the vehicle. My lord, if the bank is allowed to obtain a court order without first notifying the hirer, the protection intended by Parliament becomes meaningless. The hirer is effectively denied the opportunity to be heard before action is taken against him. My lord, the principle of natural justice requires that a person affected by a court order should have been given the opportunity to be heard. This is known as the audi alteram partem rule, meaning hear the other side. Had that respondent been informed of the application, he could have challenged the allegation regarding default or raised other relevant issues before leave was granted. Instead, the application was made entirely without his knowledge. We therefore submit that the leave order was improperly obtained and should be set aside. Furthermore, allowing ex parte applications create the risk of unfairness because the court hears only one side of the story. For their reasons, we respectfully request that the appeal be dismissed.
Thank you, Counsel. Counsel for the appellant, you may now proceed.
Much obliged, my lord. With respect, the appellant submit that the High Court adopted the wrong interpretations of Section 16(1)(a). My lord, the respondent treat this order as though it's automatically authorized repossession. That is not the case. The order simply allows the statutory process to continue. The purpose of obtaining leave is merely to satisfy the court that two statutory requirements exist. First, the hirer has paid more than 75% of the cash price. Second, there has been at least two consecutive defaults in the installment payments. Once those conditions are established, leave may be granted. However, repossession does not occur immediately. After obtaining leave, the financier must still comply with the statutory procedure under the Hire Purchase Act. Specifically, the financier must serve the fourth schedule notice informing the hirer of the intended repossession. The hirer is then given at least 21 days to remedy the default. Therefore, the hirer is not deprived of the right to be heard. In fact, the Act itself already incorporates the procedure safeguards. The respondent will receive notice. The respondent will know the amount of arrears and the respondent will know the total outstanding sum. And the respondent will have the opportunity to make payments or challenge the notice. Accordingly, natural justice is perceived. My lord, Section 16(1)(a) is intended only as procedural safeguard before the statutory notice process begins. It's not intended to create a full adversarial hearing at the leave stage, but for this reason, we respectfully ask that the appeal will be allowed.
Having considered the submission of both parties, the court now delivered its judgment. The courts find that the appellant's interpretation is correct. The purpose of Section 16, Clause 1A is limited. The court merely allows the owner to commence the statutory notice procedure. It does not authorize immediate repossession of the vehicle. The court further finds that the hirer's right to be heard is already protected through the fourth schedule notice. The notice informs the hirer of the intended repossession and gives the hirer an opportunity to settle the arrears or challenge the notice before repossession occurs. Accordingly, the requirement of natural justice is satisfied. The court therefore holds that an application for leave under Section 16 Clause 1A may be ex parte. The appeal is allowed and the decision of the High Court will be set aside. The decision of the Magistrate Court is reinstated. Court is adjourned now.
An absolute win for financial institutions, but an eye-opener for the consumers. So to better understand the significance of this decision, we are joined by our legal researcher, Miss Emilia. So Miss Emilia, could you explain the relevant provisions of the Hire Purchase Act involved in this case?
Of course, the easiest way to understand this case is to look at the 75% of the repayment level. Under Section 16, subsection 1, where the hire has paid not more than 75% of the total cash price, the owner may repossess the goods provided that there have been at least 2 consecutive defaults. The required fourth schedule notice has been served and the hire has been given at least 21 days to respond. However, when the hire has paid more than 75% of the total cash price, Section 16, subsection 1A applies. After leave has been granted, Section 16, subsection 1B requires the owner to serve the fourth schedule notice and wait for the statutory period to expire before repossession can take place. What makes this case significant is the Court of Appeal's clarification that the leave obtained under Section 16, subsection 1A is not permission to repossess the vehicle immediately. Instead, it is merely permission to begin a statutory notice procedure. The court also confirmed that the application for leave may be made ex parte because the highest right to be heard is already protected through the fourth schedule notice and the 21-day period provided under the law. This clarification is actually one of the major contributions of this case.
Fascinating. Thank you, Miss Emilia. Now, let's cross over to our industry specialist, Mr. Hazim, to discuss what this means practically for the market and the new industry initiatives being proposed.
So thank you. One thing I find particularly interesting about this case is that it reminds us the ownership of the vehicle still remains with the bank until the loan is fully paid. So however, having that ownership right doesn't mean that the bank can ignore the legal process. So if the required procedure are followed properly, the repossession itself may not stand. So this case offers several valuable lessons for commercial practice. So first, financiers must strictly comply with all statutory requirements before repossessing any vehicle. So even where a customer has defaulted, repossession cannot be carried out arbitrarily. So second, businesses should keep proper records of installment payments, defaults, notices, and court application, as this document may become crucial evidence in the legal proceeding. So third, this decision brings certainty for financial institutions. So the court confirmed that application under Section 16, subsection 1A may be made ex parte for the purpose of verifying compliance with all statutory requirements. So the fourth, consumers should understand that paying more than 75% of the vehicle price does not prevent repossession altogether. So instead, it gives them additional statutory protection because court leave must first be obtained. So ultimately, this decision demonstrates how commercial law seeks to balance competing interests. On one hand, financiers need effective remedies against defaulting hirers. So on the other hand, consumers deserve protection from unfair repossession practices. So that's why many legal and industry experts are now encouraging stronger consumer awareness measures. So one proposal is to place QR codes on statutory notices so borrowers can immediately understand their rights and available options. So bank could also introduce early warning system to alert customers when they are approaching the protected 75% repayment threshold.
Based on all those insights, we can conclude that this case is an important authority on the repositions provisions of the Hire Purchase Act 1967. The Court of Appeal clarified that leave applications under Section 161A may be made ex parte and that the hirer's rights are adequately protected through the statutory notice procedure. The case highlights the importance of procedural compliance, consumer protection, and commercial certainty in hire purchase transactions. That concludes our broadcast for today. Thank you for watching, and we will see you on the next legal updates.